I think we're about ready to start. Welcome for joining me on the webinar today. We're going to talk about a few things to help you guys dealing with constructive dismissal, unfair dismissal, and wrongful dismissal. Let me just get this set up for you. Okay, so welcome to the webinar. So the first one we've done from Youth HR. We're wanting to sort of share information, see how we can help educate people more in terms of how they can deal with workplace problems. Today's topic, as you can see, is obviously unfair, wrongful, or constructive dismissal. What I'd like to do is, as I'm talking through the topics of today, if you have any questions, there's a chat box at the very top. You can ask me any questions and I'll be checking it as we go through it. And I'll obviously answer anything I can help you in any sort of way. What I'd like to start off with, to begin with, is understanding exactly who is here and why. So generally speaking, the type of people we're dealing with in this particular room and anywhere with our clients, well, would be people who are dealing with the employment problems in the workplace, whether they are HR people or directors or finance directors or anybody who has to deal with the people problems. And why you're here, I'm presuming, is because the topic is of interest to you, how to deal with unfair dismissal cases, constructive dismissal or wrongful. What I'm going to leave you with, or what you're going to take away from this, is a few tips on how to deal with certain situations, things to think about when you're dealing with these types of situations. And also I'm going to give you a few shortcuts that you can use to apply from a practical point of view to get the outcomes that you're kind of looking for. Okay, unfair dismissal. So what's the difference? Unfair dismissal, wrongful dismissal, and constructive dismissal. Unfair dismissal effectively requires 2 years service for an employee. Otherwise, there's no legal jurisdiction for the person to even claim unfair dismissal. Unfair dismissal, in law, you need a fair reason to be able to terminate an employment after they've got 2 years. That basically means for the first 2 years of service, an employer can dismiss an employee for pretty much any reason they like. There's only two categories which there's an exception to that. One is if it is automatically unfair, which doesn't require the 2 year service. And one is where there's a discrimination element. Discrimination on the grounds of race, sex, religion, age, disability, that sort of thing. Automatically unfair dismissal, which doesn't require 2 year service, relates to things like if you're dismissing an employee because they're pregnant, or because they're a member of a union, or perhaps they're asserting certain legal rights, like claiming holiday pay or that sort of thing. Those things don't need 2 years service. Wrongful dismissal relates to situations where it's a breach of contract claim. So if you are terminating an employee and you're not giving them the right amount of notice, they're entitled to their notice pay. So a breach of contract claim is effectively where they're entitled to any losses that they suffer as a result of you breaching the contract. Constructive dismissal is the flip side of unfair dismissal. So where instead of being unfairly dismissed, you're effectively being pushed out. What you need to demonstrate for that, or what an employee needs to demonstrate for that, is a fundamental breakdown of trust and confidence, something that makes it untenable for the employment relationship to continue. Okay, no questions just yet. Let's keep going. So what do you pay when you get it wrong? So for discrimination claims, and I know this is mainly about dismissals and wrongful, unfair, and so forth, but I can't really avoid talking about discrimination in these sorts of situations. For a discrimination claim, if you get it wrong, there's no cap actually for the discrimination claims. It can happen in those sorts of situations. Generally speaking, though, there's something called injury to feelings. And injury to feelings falls into 3 different bands, and the top band is worth up to £42,000. So it's really important that you get things in place to prevent that sort of claim from happening. I'll talk about that a bit later on in this webinar. For unfair dismissal or constructive dismissal claims, employees are entitled to up to 1 year's pay or £83,682 as a cap, whichever is the lower of the two. So a lot of people think unfair dismissal is based on how you dismiss them. It's unfair, fair or unfair. But in reality, what they're compensated for is the loss of earnings as a result of being unfairly dismissed. So, and that's subject to your ability or their ability to get another job. So if they can get a job within 6 months, then they're entitled to up to 6 months' pay. There is something where if you fail to follow the procedures, there are certain uplifts in place. But assuming you follow the right procedures, then you will be, and you have a fair reason, then you won't be looking at an unfair dismissal claim. Unfair dismissal, fair dismissal, you need to have certain reasons in place. That could be redundancy, that could be misconduct, it could be illegality, it could be capability, or it could be some other substantial reason which basically covers everything else. A wrongful dismissal, as I mentioned before, if you don't pay their notice pay when they're entitled to it, then that's what they're entitled to claim, or any other breaches of contract for that matter. The other thing, if you get it wrong, obviously, is you end up paying lawyers a lot of legal fees. You're paying by the time, you're paying by the hour. That could be like a blank check, unless you're doing some sort of fixed price arrangement. The other thing is if you have legal expenses insurance in place, then your premiums will probably end up increasing, but it's better to have something in place to protect you in case things go wrong. So let me talk to you about what's involved for a fair dismissal. So I mentioned previously that you need at least 2 years service to claim unfair dismissal. So basically an employer can dismiss an employee for any reason they like when they've got less than 2 years service, unless it falls within the discrimination category, or if it's something that's automatically unfair. You need a fair reason and you need a fair procedure. The fair reason, as I explained, has to be falling with one of a number of categories. That would be redundancy, capability, misconduct, illegality, and some other substantial reason. The fair procedure has to be something that's reasonable. So it starts off with a reasonable investigation. So if you have an allegation against somebody, you have to investigate that reasonably. Get witness statements, see what documentary evidence that there is to support whatever the allegations are. The next thing is the way that the meeting itself is conducted has to also be conducted fair and reasonably. So that means the person that's dealing with that chairing the meeting, which shouldn't be the same person that's conducting the investigation, should look at it with fresh eyes. They should be able to look at it impartially, not in any kind of biased way, look at the evidence and to determine on a balance of probabilities what it is that they believe the outcome should be. The third thing you need to have is a right of appeal. So the right of appeal is a really important bit, because if you carry out the appeal as a rehearing of all the issues rather than just a review, then you can actually remedy any earlier defects in the process that you'd followed up to that date. So it's really important that you give the right of appeal and you conduct it as a rehearing. So what's the difference between a review and a rehearing, I hear you say? So the review is where an employee appeals against their dismissal, and they appeal, let's say, on points 1, 2, and 3. And then the appeal is conducted around those points of appeal. A rehearing looks at those points of appeal and the whole situation again. By looking at everything again, you get to fix anything that may have gone wrong in the process before, and so you effectively get a second bite at the cherry. The other thing you need to give an employee is the right to be accompanied. Right to be accompanied relates to being accompanied by a member of a trade union or a fellow employee from the company. It doesn't relate to your mother, your brother, your mate, or even a lawyer in most circumstances. The burden of proof. So this is an important thing to understand, in the sense that most people think about TV, law, criminal programs or what have you, where the criminal burden of proof is beyond a reasonable doubt. In employment law, it's what's called a balance of probabilities. What that actually means is, what does it look like? It's a 51% rule. What's it likely to be? So when I say what does it look like, it doesn't necessarily even mean what is the truth. It means what does the evidence suggest is the most likely scenario. So it's on a balance of probabilities that you need to determine. It's quite a lower burden than a criminal burden. Again, I've already mentioned the fundamental right of appeal. By getting that right, you can correct any earlier defects that may have occurred during the disciplinary process up to that time. I'll have a quick look to see if anybody's got any questions. Okay, I must be doing well. There's no questions yet. Oops, speeding ahead. Okay. Managing underperformance and sickness absence. So again, we're talking about people with more than 2 years service. This is where you have these obligations. Less than 2 years service, you don't necessarily have the obligations, apart from if it's automatically unfair or if it's something that's discrimination. So with underperformance, what a lot of companies do, a lot of employers do, is they deal with a failure to meet targets, for example. But managing underperformance isn't about just telling employees, this is what you're not doing. It's really important that you tell them what it is that what's expected of them and how they're expected to do it. Not just you should meet the target of X amount. If they knew how to do that in the first place, they wouldn't be looking at these sort of disciplinary actions anyway. I'm going to hear about the super nanny approach. I'm sure most of you have seen that program with the super nanny. I can't remember the lady's name now, Joe something or other. And what she does is she goes into homes and she deals with unruly children. And she tells the children exactly what the expectations are. And if they fail to meet those expectations, they end up on the naughty step. The employment law is basically super nanny. 3 naughty steps and you've got to be out of the house. So the way to look at it is, I'm not suggesting it in any kind of patronizing way, but you need to make it very clear to employees what the required standards are and how you expect them to meet those standards. So if it's targets, like the example I just gave, that should be something like, for example, maybe there's a certain number of calls they need to make a certain number of appointments to then generate a certain amount of revenue. That's a very basic example. If there are appraisals in place and the informal approach fails, and I do actually generally advocate just having a grown-up conversation with your staff. You don't have to jump straight into disciplinary action about every single issue. But if that fails, then you adopt the disciplinary process that I mentioned before, setting out what the required standards are and what the consequences will be if they don't meet the required standards. The key, as I was saying earlier with the super nanny approach, is just to be firm and fair, make it very clear what the boundaries are and how it is you expect them to do what they're supposed to be doing. A very common question, so dealing with sickness absence, a very common question I get is can you be dismissed for being off sick? The short answer is yes, but it depends on what the circumstances are. So if it's more than 2 years service, then what you need to be able to do is get a medical report, determine what you can do to help that person come back to work, and if there's nothing that can be reasonably done and you follow the correct procedure in the way that I mentioned before, the same as the disciplinary procedure would be the same for a capability procedure, you ask the doctor exactly what it is you can do to help them come back to work. If they can't come back to work or you can't do anything to help them come back to work, then it will be a lawful dismissal. With less than 2 years, as long as it is anything related to a disability, in which case an employer has something called an obligation to make reasonable adjustments, then again you can dismiss them. Another thing that I often get asked from clients is whether they can call the staff while they're off sick. There's absolutely no reason you can't call your employees whilst they're off sick, as long as you're not bugging them about work issues, as long as you're not harassing them in any way. But if there's something that would be useful or it's a conversation that's quite sensible, then there should be no reason that you can't call somebody while they're off sick. But again, the key in terms of dismissal is, have you followed the right procedure? Have you got the right medical evidence to support the decision to dismiss, because you can't do anything to reasonably have them back? Contracts. So let me start with that part. So why do we need contracts of employment? What's the point of having them? So a lot of companies don't in fact have them. But the contract is there so that if things go wrong, or if there's a dispute of any kind, the contract's supposed to lay out exactly what the deal is. We know what is expected of each other. Employees know what their salary is, what their pay is, what their job is. Employers are also very clear on what they expect from the employee in those circumstances for those terms and conditions. So the contract sort of lays out the foundation of what's expected between each other. So if things go wrong, if there's a dispute later on down the line, you can refer to the contract to be able to justify what it is that's expected of the employee. One of the other things you should be aware of is, if there's a claim for unfair dismissal, if an employee is entitled to make a claim and you don't have a contract, and the contract hasn't been provided within the first 8 weeks of employment, then they're entitled to make a claim for up to 4 weeks' pay. Again, as I mentioned earlier, the purpose of the contract is to create certainty of terms and to avoid any kind of dispute between the two. Generally, the contract should set out their start date, hours, pay, notice, holiday pay, all those sorts of things. But one of the main things I think that a lot of company clients that say that they need their clarification of the contract are what are called restricted covenants or post-termination restrictions, stuff you can't do after you leave the employment. So that would be things like stealing their clients or taking their supplies or doing anything that would damage the business going forward. It's important that you have the restricted covenants at the start of the employment. It may be problematic to try and implement those things at a later stage. Repudiatory breaches. So again, if you can show that the employee has not done what they're supposed to do and it's a fundamental breach of the contract, well then that's again something you can rely on under the contract of employment. Changes the terms and conditions. You can also give a business justification for making those sorts of changes within a contract, but sometimes it's good to refer to those things in the contract itself. The other reason the contract it will be good to have in place actually it's probably more with the handbook, which I'll get onto in a second, is you're able to justify why it is that the behavior of an employee or whatever the reason you're dismissing them for is taking place, because it will have been explained to them already. The company handbook. So company handbooks are there basically to say this is how we do stuff. This is how we operate. It will talk about what your maternity policy is. It should have in there what your paternity is, what your data protection is, what your internet policy is. You know, you're not looking at Facebook and all the rest of that during your lunch break probably. Whatever it is, it should say exactly what is or isn't acceptable and what the consequences are. Again, back to our super nanny approach, making it very clear what is expected of the staff at any given time. When you have a company handbook or employee handbook, having all your policies, it's important to not make it a contractual document. Contractual document means that you're obligated to follow whatever it says in the handbook. By being obligated, if you fail to follow what it says in there, then you could be in breach of contract, which means that you might have to end up paying damages for the losses that flow as a result of that breach. So rather than making it contractual, make sure that it's a guide. It's an option that's open to you to use on how you want to deal with any given situation. The other thing about having a handbook is not just a document that you give or policies that you give to staff and it ends up in a drawer. It's got to be something you actually train your staff on. Because when you do that, if they discriminate or if they do something that is in breach of that agreement, you can rely on the document. This is called a statutory defense. You can rely on the document to show that you did everything you could reasonably or practically do to stop that type of behavior from happening. In which case, as an employer, you can absolve yourself of that responsibility. What you need to be able to do, as I say, is train your staff on the handbook so they know exactly what it is that's expected of them and they can apply those things in a real working practice. If it's just a tick box exercise, it doesn't really work in the same way. Okay. Oops. So what happens if you don't educate your staff? What happens if you don't follow the right processes or it does end up in the drawer? So compensation for discrimination claims, I said I wouldn't talk about it too much, but I can't really avoid it because I think it's relevant for you, is up to £42,000 for injury to feelings. I mentioned that before, but it can be uncapped in certain circumstances. When you have a policy or policies in place for equal opportunities or discrimination, those sorts of things, and you trained your staff properly on that, what a lot of staff or employees don't know is that they can be held personally responsible. It's not just the employer. When you make a claim for unfair dismissal, it's only ever against the employer. You don't claim against the employees as well. But for discrimination claims, you can claim against the employer and the employee who has carried out the act of discrimination. It's called vicarious liability in terms of like a parent being responsible for the child's conduct or a teacher being responsible for their student. So normally, the employer would be held responsible as well as the individual. But if you put the right training in place and it's made clear to them, you can show that it's been made clear to what's expected of them in terms of certain types of behavior. Actually, it doesn't necessarily just mean in the workplace. It can be in work functions and outside of the workplace too. Then when employees realize that their neck's also on the line or they're also on the hook, perhaps that will correct their behavior as well. They understand that there's a consequence to them too. Again, handbook it goes hand in hand with the contract really. It just sets out very clearly what's expected, how we operate, and what the consequences will be if you don't do the things that we said we asked you to do. Okay, so we've gone through the employment contracts, we've gone through the company handbook. Disciplinary procedures. I just wanted to mention one more thing is there's no set template that you need to use. It might be something that's relevant to your business, but whatever it is, the more details you can put on what is or isn't acceptable disciplinary conduct in the handbook, the clearer it is to staff what is or isn't acceptable. Obviously, you want things that relate to dishonesty would amount to gross misconduct. Obviously, things like unauthorized absence or alcohol abuse or whatever other things you might do in the workplace that's completely unacceptable, but spell it out. Educate your staff and give them real training. The other thing to make sure you have to avoid these types of claims, get some legal protection. I know I would say that, but it's true. You should get the right advice, make sure there's at least a soundboard you can rely on to not just deal with issues as they arise, perhaps help you to prevent those things from happening in the first place. What you want is not just advice on the law, but practical support to deal with real situations. Why bother? So there's two things to think about here as a business. You want to think about whether you want, are you just looking to do the right thing to follow best practice, or are you looking to do what is in the best interest of the business? Because there's a difference. Best practice can obviously avoid costly tribunal claims, but depending on the length of service and various other factors, actually there's shortcuts that you can follow to avoid the whole process. And I'm going to go through that with you right now. Without prejudice. So some of you probably will mostly be familiar with this phrase. Without prejudice effectively means it's off the record, or they're normally discussions that relate to a dispute happening of some kind. And the idea is that you can openly speak with the employee about whatever the issues are without fear of being sued. So what I'm suggesting is there are shortcuts to these processes. I explained to you earlier that, for example, an unfair dismissal claim is worth up to 1 year's pay, but it's subject to their ability to get another job. So you do have a choice where if you decide that it could take 6 months to go through a disciplinary process and you end up paying them 6 months, and then following the disciplinary ladder, which would be a verbal warning, first written warning, final written warning, then they're out. Or if you know they can get a job within a certain period of time, let's say within 1 month, well, then you know if you follow the right procedures, well, actually the liability will only be 1 month's pay. So I'm a big advocate of just having a grown-up conversation. If it's not working out, why not agree it with the employee? And it's very tricky, these types of discussions. So I'm going to absolutely advocate you get some legal advice on how it's done. But effectively, if you can agree it with the employee and make it very clear to them what the consequences are, or what their potential liability is, or the risk, or if it's made clear to them what they would get if they went to tribunal anyway, because you've managed the risk, and you manage the risk by finding out how long it will take them to get another job, well, it's very likely, the success rate is very high in my experience, of being able to persuade them to agree to a what's called a settlement agreement, which means that everybody can part ways amicably. Again, it depends on what kind of organization you have and what your mindset is in dealing with these types of situations. If it's to get the solution rather than just following best practice, well, then I'm going to advocate this as an approach. Sometimes there are employees that are just not working out, it's becoming a headache, and you just need to resolve the issue quickly, in which case you want to understand practically on how to manage the consequences. You know, most people think you can't do this because of the law, you can't do that because of the law, but the reality is you can do anything you like, as long as you're prepared to manage what the consequences are. So it's important you get the right advice on how to manage those sorts of things. So how can we reduce the responsibility? Train your staff, tell your employees, tell your agents, tell everybody how it is you operate and what you expect of them. Get some equality training in place. Contracts of employment, get them all legally up to date, and make sure that they're being applied across the board. Be able to demonstrate that you took all the right steps that you needed to take to be able to stop this type of behavior from happening. And let employees know that they're personally responsible for certain types of behavior, obviously, particularly in discrimination. Once they know that, they tend to perhaps correct their behavior. So that's pretty much it for this first session. I hope you've kind of got, it was a very whistle-stop tour, I appreciate it. It was, we had to cram a lot in a very short space of time, but I hope you kind of got a flavor or at least an idea of what it was you're looking for. If you didn't and you want some more information, please feel free to call me or email me. I'll happily speak to you about any questions that you have, either about this slide or any other HR problems that you're dealing with. My details are at the end of this slide. I'm clean shaven there. But either way, contact me. My details are there. Call me anytime. And thank you very much for listening. Let me have a quick look to see if there's any other queries from anybody. Okay, so either you're too shy or I've answered all of your questions. Either way, do contact us, and I will be doing another presentation, another webinar in a month's time. We'll be making this a regular thing if this is of interest to people in terms of helping them in running a business. Thank you very much for attending. Bye-bye.